My name is David Hodson. I'm a solicitor, mediator, arbitrator and a partner in the International Family Law Group based in Covent Garden in London. I'm editor and one of the authors of the International Family Law Practice published by Jordan's. The fourth edition was published in spring 2015, and this autumn 2015 we've now produced the online version, the digital version, with an update for early autumn 2015. One of the chapters has been written by one of my partners, Anne Thomas, on the question of relocation of children. This is an increasingly important issue. It's an issue that's coming up more and more as more families travel around the world. How does it arise? It certainly arises at a time of divorce where one of the spouses, one of the parents may say, I want to go back to my home country, or I want to move on my work or because of a new relationship, and I want to take the children with me. It arises years after a parental separation, perhaps a divorce, where somebody has got a new job abroad, a new relationship, or they want to return to their home country, or in other ways want to move abroad with the child. And this can cause a real friction. This is one of the most problematic and emotionally difficult areas that we family lawyers have to deal with. When a couple separate, there's various shades of grey as to whether it should be a period of contact for a long weekend, a short weekend. It's a matter of compromise. If the parents are not too far away, it can be varied from time to time. Whereas this relocation, it tends to be a binary decision. The child will either be in England or will be in another country. And it's a very polarised, a very binary issue. The court's got to decide this country or that country, and one parent will be immensely unhappy at the outcome. For very, very many years, from the 1970s onwards, our law of relocation was based on a case of pain, and this had become almost as if it was statute law. It was embedded. There was no cases that really ever went against it, and it was perceived as really a charter for the parent, invariably the mother, who wanted to move abroad. And it was effectively a two-stage process. First of all, was the application genuine? Was it motivated by the best interest of the child, or was it motivated by a chance to get against the other parent? And secondly, was it realistic? Was there a realistic opportunity in the other country? Was it financially viable? If that was so, then almost it became a burden on the other party, invariably the father, to show why this shouldn't occur. He had to show the impact on him. He had to show that his opposition was in the best interest of the child and not for any other reasons getting against the other parent. It almost became a question of what's the impact of the refusal on the mother and the relationship with the child. And so there was a perception throughout the 80s into the 90s and the last decade that it was almost a passport for the mother, if she was the applicant, to leave with the child. It was much criticised, but as I say, it had almost become the status of statute law. There was cause for it to be repealed, almost to be overturned, and then we had the case in 2011 of CK versus MK. And this didn't say that pain was bad law, but it said the paramountcy was the best interest of the child. Pain was still good, it was still appropriate, but now we should look at the best interest of the child. And in the case of relocation, in some ways even more so than looking at contact, the best interests of the child really have got to dominate. This child is potentially going to be uprooted from one country and taken to another. The best interest of the child should be the crucial element for it. And then earlier in this year, 2015, we've had the case of Re-F, and that has emphasised yet again the importance of the welfare of the child, the best interests of the child. Pain is still relevant. Pain can be looked at, but pain does not now govern relocation. There's a couple of other areas where this is of importance. Relocation cases are pretty well defined now for what's known as external relocation, outside the borders of England and Wales. But people may want to move around the country. Now that may be one side of London to another, where the transport difficulties, particularly contact of a Friday evening, could be quite difficult, or it may be Exeter to Sunderland across the breadth of the country. And the law here is that the external relocation law is applied, but more softly, more gently. There's an expectation that in some ways it's easier to have contact. For myself, I don't think that's realistic. For some families, modest means, a move from one side of the country to another is as hard, if not much, much harder, than for a family of reasonable means where one wants to move from London to Brisbane or the other side of the world. There's got to be a realism in these international cases and then these internal relocation cases. We have had a decision, we've had a hearing in the Court of Appeal, we're expecting a decision from the Court of Appeal on internal relocation cases sometime in the early winter 2015. Another area is the temporary relocation, where the child goes abroad for a temporary period. And this is often put forward as a halfway house. This has all sorts of problems. Will the child return? One big issue is if the child goes abroad for a year on a temporary basis, the habitual residence of that child is now the other country. Which court has got jurisdiction? Often these things go hand in hand with an anxiety about abduction. Will the child ever be returned? And so one may want to register the order in the other country. One may actually want bond or security or some other way of knowing the child will be returned. Take great care on these temporary relocation cases. As lawyers, solicitors, barristers, we've got a particular responsibility in relocation cases for the preparation, the work we do. Yes, there is the law, but how we do the preparation is crucially important. The first letter that is sent is of fundamental importance. It needs a lot of care. It needs to be sensitive, it needs to be understanding of the so-called left behind parent, it needs to put forward good contact arrangements, it needs to recognise the financial element, it needs to recognise the impact on the left behind parent. How can the relationship be maintained? It needs to offer Skype or similar contact to maintain it. The first letter is very important. And then the next stage is the statement. This won't be a short document. This will need a lot of homework. It will need a lot of preparation. Where will the child be living? What school? What arrangements for travel back? What contact? How can it be afforded? It must be generous. Be open and be offering to the left behind parent. This is not a short job. It's not a cheap job either. And one of the concerns in the relocation cases is that the costs of these matters can be very, very high, and they can be self-defeating of the very hope that the parent has got in actually moving to another jurisdiction. Be very, very careful of the costs of these matters. And mediation is a very good way of resolving relocation disputes. There can be privileged discussions, proposals can be made in mediation that actually wouldn't be made in open court proceedings. There can be ways forward. The arrangements for the child can be sorted out in hand with the financial implications. This can be done in mediation, which is not so easy often to do within court proceedings. So these cases are very fraught, they're very emotional, and I would certainly, as a mediator, having done a number of relocation finance-linked cases as a mediator, want to very much encourage the use of ADR of any form to find a way to overcome the real intensity of costs, the real litigation that can go with some relocation cases. The law is clearer. It is now the welfare of the child. It isn't the pain principles. The preparation for the case is crucially important by us practitioners.